Property condition. Okay, access inspections and utilities. Seller shall permit buyer and buyer's agents access to the property at reasonable times, okay? Buyer is always allowed to have the property inspected by inspectors. And the seller is responsible for turning on utilities for inspectors, okay? Seller's disclosure notice, that's pretty clear. Well, because this paragraph here says the seller shall have the utilities on, if the seller does not have them on, the seller is in breach of that provision of the contract and the buyer is empowered under the default paragraph. So, and if there are other damages that the buyer has incurred, such as paying for the inspection or something like that, then the buyer also has the option of not necessarily going after earnest money, but going after damages that they've incurred. So unless there are certain repairs that are going to be completed to the property, they need to be included in that paragraph 7D. That's where you talk about what repairs are going to be done. Specific repairs and treatments. Okay, lender required repairs and treatments. Unless otherwise agreed in writing, neither party is obligated to pay for lender required repairs, including treatment for wood destroying insects, okay? If the parties do not agree to pay for the lender required repairs or treatments, this contract will terminate and the earnest money will be refunded to buyer. If the cost of lender required repairs and treatments exceeds 5% of the sales price, buyer may terminate this contract and the earnest money will be refunded to buyer. Did y'all catch that? No? Okay, let's go through that again. Okay? We're talking about lender required repairs. Neither party is obligated to pay for lender required repairs. If the parties do not agree to pay for lender required repairs or treatments, this contract will terminate and the earnest money will be refunded to buyer. If the cost of lender required repairs and treatments exceeds 5% of the sales price, buyer has the right to terminate the contract and the earnest money goes to the buyer. Okay? So lender required repairs are a tricky thing. Completion of repairs and treatments. Seller has until the closing date to perform all agreed upon repairs and treatments, okay? All repairs must be performed by persons who are licensed or otherwise authorized by law, whatever that means, to provide such repairs or treatments. Okay, at the buyer's election, transferable warranties received by seller with respect to repairs will be transferred to the buyer at buyer's expense. If seller fails to complete any of the repairs prior to the closing date, buyer may do so and be reimbursed from the seller at closing. All right, and then the closing date can be extended up to 15 days to complete those repairs and treatments. Closing. The closing of the sale will be on or before blank or within 7 days after objections made under paragraph 60 have been cured or waived. All right.
Date specific?
Is what now?
Could you say next week sometime?
Oh, no. It does need to be a specific date in this paragraph or a date that is determinable. Okay? So if you said, well, I'm not going to say that, but.
As soon as we get the loan approved.
No.
As soon as we get the loan approved.
No, that's not acceptable. It needs to be a specific date, a date certain if you want to call it that. But from a legal perspective, according to this contract, you know, the FHA underwriter is not performing still doesn't mean that this closing date doesn't come and go and that the parties don't have to perform on that closing date. So if the buyer, let's say, is not able to perform because they can't get their loan, then the buyer is going to be in default.
If you are the listing agent and you have a fully accepted contract that involves third-party financing and you have a letter from a lender that says we're going to make these people a loan assuming that everything they told us was true and they still have a job and all their credit is really written, which really means nothing, that you can call that lender as a listing agent and find out some things. And sometimes you will be told by the lender, I'm not going to talk to you, you're the listing agent. I just want to point out a sentence to you that if you have a third-party financing condition addendum signed by the buyer, the very last sentence says, buyer hereby authorizes any lender to furnish to seller or buyer or their representatives information relating only to the status of financing approval of the buyer. So you are the representative of the seller. You have the right to ask the question about financing approval. Now, the lender doesn't have the right to tell you details, but they can say, we do have an application from these people, we have met with them, this is what it looks like. They're not going to tell you how much they make and all that kind of stuff.
Knows that you are only ever to input factual statements and business details, okay? Be careful about drafting. We're getting into legal drafting, or drafting which requires a law license, because I know the Real Estate Commission is enforcing those complaints these days. They're seeing a lot of it. Okay, so just be very careful. Only factual statements and business details. And really, I don't like to see anything in special provisions.